All right, hi everybody. Super excited to get going here. So, just a heads up, this session is going to be recorded. I candidly have no idea if your written comments using the chat function will be recorded, but anything you speak in will be recorded. So that's just an FYI. And as we get started here, if I could ask, can folks just confirm either? I think it's going to be most easy to ask questions via the microphone function. So if we just go down the line, there are 4 of you on the line right now, and just when I call out your name, if you could just test and see if your microphone function is working, that would be great. So Jason, can you give it a try? Let's see if yours is working. Can anybody hear? I can't hear Jason. Let's try one more time.
Hello.
Hang on. Jason, try one more time.
Can you hear me?
Yep, got you. All right.
Can you hear me?
Jason, we're live.
Hello.
Yep, you're good. Jessica, can you give a try with your microphone?
Yeah, can you hear me?
Sure can.
Oh, good.
And John, can you give a try as well? So John, I could not hear you. It sounded like you're trying to use the function. All right, John, let's just hang on a sec. So John, hopefully if you could just confirm via writing via chat that you can at least hear me talking, then we'll be ready to rock here. And apologize, folks. Once we get going in this, will be pretty seamless. Excellent. All right, so we're going to get started. There may be some folks joining along the way, which is fine. And, for those folks that are listening after the fact, there is a handout that goes with this, which we'll be referencing throughout. And, just to make sure for all of you that are joining right now, Pardee sent out a handout, I think was probably this morning, within a half an hour before this. So if you have that with you, great. If you don't, using the screen share function, I currently have up an agenda for where we're going today. So that's your alternative if you don't have it handy. Stop me if you don't have it. Otherwise, we're going to dive right in. All right. So the intent for today's workshop is kind of to talk through threshold issues, or I'll reframe what I think the intent is to talk through kind of threshold issues in leasing. And in the past, we've been heavily focused on retail leasing. I know, Jason, for you, and Jessica, you're at Union Square Main Streets, correct?
Yes, I am.
Great. So I assume for both of you, retail leasing is probably at the forefront of kind of the way in which you're thinking about this workshop. And I would say that my specialty is also in retail leasing. So John, I know we had a hard time with your microphone. Is you coming to this at this point kind of focused on ground floor retail use or otherwise? And by the way, respond when you have time, but I'll be checking the chat just to kind of get your answer. So I think today's focus really is going to be very much on retail, but a lot of the concepts we're going to discuss, thanks, John. A lot of the concepts we're going to discuss are certainly relevant to upper floor uses and office, but certainly it's focused on commercial leasing, to be very clear. And in some ways, I think retail leasing is a bit more challenging than office because there are many more issues that are triggered by the use of the real estate and by the various different retail uses. Certainly things like signage, trash, loading, the potential for disturbance of kind of whether it's residents or office above or neighbors. And we'll talk through some of that. And I think the one thing I would certainly highlight as a preliminary matter would be, I think there's typically a rush to lease, or at least a rush to the leasing process. And one of the things I'd like to kind of talk through with you all today is my belief very much that the leasing process goes far, far better. And tenants, looking at this from the tenant perspective, as well as landlords, end up getting far better results when they're very organized going into that leasing process. And that's where we'll start today. So as a quick preview in terms of the agenda, we're going to start just going over some threshold matters, which I've listed out some of them in the introduction section. We'll flow into one of the areas that I think is absolutely critical, and without it, there is no lease, which is, how do you go about searching for real estate? And, I think Jessica and Jason, you'll probably have some good feedback as well, given kind of your closeness to this matter. And then we'll spend the bulk of the session going through a term sheet. And I say a term sheet instead of a lease because I think whether or not you have a term sheet or a letter of intent, or a landlord provides that, or even a tenant provides that, I want to spend some time talking about kind of the core issues that should be incorporated into a lease document, primarily from a business perspective. And from there, we'll talk a little bit about who should be on the team as you move to lease. And I've included in the handout two very different examples of leases. One is a very short form lease that oftentimes landlords will use who may be less institutional, less corporate, potentially less sophisticated, but not necessarily. And the other one is a more traditional table of contents for a lease document for what I would call a long form lease. And this is the kind of lease that I think more institutional and more corporate landlords are using these days. I would flag, and I think it's probably accurate, that in Cambridge, I would say Somerville as well, given some of the changes we're seeing in the real estate market and some of the kind of transactional velocity in commercial real estate, we are seeing far more investors, developers, institutions as landlords than at any moment in the past. So I think what ends up happening is we're seeing much more robust, arguably complicated lease documents that local businesses are having to deal with. That does not change the reality that there are certain threshold business issues that have to be dealt with first. And that's really kind of what we're going to hit on today. So that's my agenda. Before I dive in, any questions from you guys? All right, great. Parties, anything that you would add as we dive in? Okay.
At the end of the 9.
And John, I know, so just to kind of make sure I understand the audience, and this is one of the challenges of doing it online, I know Jessica is in a leadership capacity at Union Square Main Streets, which is a great organization that works with a lot of small businesses. Similarly, Jason does some of the same work for East Cambridge Business Association. So I think their orientation is very much from the tenant perspective. When you have a moment, if you could let me kind of know what perspective you're coming from, that would be really helpful. And I think in very many, we can certainly gear this presentation towards that perspective. I think that I found that oftentimes it is the tenants that need the most assistance, and this workshop is no doubt geared toward the tenant perspective. Certainly not geared towards the landlord perspective, but I will end today talking a little bit about what it is landlords are looking for from tenants, which I think is really, really critical, and really, really critical in kind of helping small local owner-operated businesses kind of position themselves for not just a successful leasing process, but to get, frankly, what they want from a negotiating perspective in the leasing process. All right, thanks, John. So, John, I think super helpful, understand kind of you're on the brokerage side. You have a unique perspective you should stop me on as well as we're going through this. So, grounding ourselves with the perspective we've chosen today, which is the tenant perspective, the small local owner-operated business perspective. I think the first thing before diving into leases is looking for real estate. And I think even before looking for real estate, there's some critical questions that all tenants need to ask. And the first one, and this is something that at Graffito, and just to orient you all, almost all of our work is working for large institutional landlords, kind of helping them lease their retail spaces. Our strong preference in the projects we work on, despite the size of some of our clients, who are almost all developers, universities, institutions, real estate investment trusts, many of which are publicly traded, our real slant is heavily biased towards local businesses for a bunch of different reasons, social, environmental, but also increasingly the reality that in today's very rapidly changing market, it is the local businesses that have the ability to pivot in the most rapid way and be flexible, which as change is occurring, that is going to be even more and more important. And we're seeing a lot of change happening in kind of not just the real estate market, but certainly in kind of in retail. And, I think, and Jason and Jessica, this is probably something that resonates with the two of you working for kind of neighborhood organizations and advocacy groups. I think that increasingly the reason that I think Cambridge and Somerville and so many municipalities and Graffito advocates for small local owner-operated businesses is largely because they're much more equipped for the modern economy, frankly, is my opinion. Which is something that's really critical when we think about positioning these tenants with landlords who typically want things like credit tenants. You hear that a lot. The idea of a credit tenant is an entity signing the lease that actually has some financial value in it. If you're a startup business or you only own one or two locations, landlords will look at you as having less credit, less value, if something were to go bad, than a multi-unit chain. And I think at the end of the day, though, we're seeing a lot of multi-unit chains really struggle. And that's been something that we've used to kind of help articulate that certain realities to the credit market from a landlord perspective are real, but at the end of the day, the real goal is to have a long-term tenant. And from that perspective, we think small businesses actually offer certainly an equal chance at success as some of these more traditional formulaic operators. So these tenants, as they're positioning themselves, I think really need to think carefully about what it is they're going to do in the physical space. And once you determine what it is you're going to do in the physical space, there's a waterfall of issues that come from that, having to do with construction and design and permitting. And I think those are threshold issues that have to be tackled before going into a leasing process. And I think part of that is having to do with the need, not necessarily for a traditional business plan, but for some sort of statement that can be used with third parties, landlords included, that details what the business is, what will be happening in the physical space, and ideally goes over some threshold issues that business needs. And different uses need different things. But in the retail game, for example, if you're working in food and beverage or a restaurant, loading and trash is really, really of critical importance in a way that for somebody selling soft goods or, for example, a Gather Here down the street from where I'm sitting, which is a great example of a local business in Inman Square, or, another good example would be thinking about some of the small non-food shops in Central Square, or certainly Harvard Square. Their loading requirements are far, far less. Other things become very, very important, though, for those sort of different uses. Signage, visibility, of course. And I think there are certain things that we'll take a pause at that, municipalities and cities can help. And one of the things, just because I'm here doing this with the city of Cambridge, I think CDD, certainly in Cambridge, and I think, Jessica, your organization in Somerville, I think in the early phases, municipalities should be looked at as being a resource and help as you start your real estate search. And that kind of bridges to our next category, which is thinking about permitting and zoning. And once you solidify and are able to articulate what's happening in your space, it will trigger all sorts of issues having to do with zoning and permitting. And I think those are issues the city can help you troubleshoot at times at the beginning. They will not help you solve, but need to be thought through. And whether it's food, whether or not you are making or producing something in the space, whether or not you are a distribution center, whether or not you are simply selling soft goods, even for a beauty salon or a place that's offering spa services and massage, or nail or pedicure, manicure treatment, there are regulations that will impact all of those things. And those regulations are in the municipal as well as the state level most often. And I think those things need to be fleshed out. And again, those things will layer into the areas in which you look for real estate and the way in which you look for real estate. And furthermore, one of the things that's always astounding to my team is, with very few exception, the folks that we're talking about, or excuse me, talking to about our projects, they're all very passionate. Many of them have a very difficult time articulating exactly what it is they're going to do in the space. And they have a very hard time describing the amount of square footage they need at times. And without understanding the amount of square feet you need and the ways in which you're going to use the space, back of house, front of house, it is very challenging to move through a real estate search. So these are all upfront issues that need to be worked through. And I think they need to be worked through before you start to tour properties for the intent of leasing. And hang on one second, I'm just allowing a few other folks into the meeting. So with that being said, the question is, and I think where I was going, and sorry I got interrupted, is that you can tour neighborhoods, which is different than touring spaces, and you can tour spaces for the intent of just trying to get a sense of what's out there. But when you are really ready to lease a space, some of these details must be fleshed out. So I want to take a quick pause here and ask John or Jessica or Jason if you have any questions as we start to move more into the kind of specifics of what goes into a term sheet and what are those business issues that need to be negotiated. Take some questions now and just allow you the opportunity to flag some issues that we may want to discuss before we go into kind of pages 2 and 3 of the deck that was provided. I'll give you each a couple more seconds to think about it. So Jessica's good. John, I'm going to assume you are good, but to the extent you want to lob in a question via the chat function, I'll stop where I'm going. Okay, great. Sounds like you have no questions. So Jessica, I'm going to put you on the spot quickly, especially because I know your microphone works. So from your position at Union Square Main Streets, does what I'm saying about tenant readiness resonate in kind of the conversations you've had with tenants?
It sure does. And also specifically, as I'm hearing you talk about the hard needs of a business to do well and do their core functions of their business, that has particular relevance for us as we are preparing for 5 years of pretty significant construction and infrastructure improvements throughout the city. So in addition to thinking that about those things in a normal day-to-day application, for us here in Union Square, we've got an additional layer of the nitty-gritty realities of businesses in the next 5 years or so.
Yeah, it's super helpful. I think it also raises a point, which I think tenants, and I think parties will nod their head at this as well. I think tenants really want to start to understand early in the process of going out and leasing space is what are the issues that are kind of under the auspice, and kind of what are those issues that involve the municipality and the city, and what are the issues that involve the landlord. And one of the things that I see very often is, was out of this? Sorry.
You're right. Sorry.
One of the issues I see really often is that tenants are coming to landlords with city issues, and tenants are going to cities with landlord issues. And there is a big difference. And it can be a real challenge when tenants don't quite understand what sits where. And I think part of it, and this kind of dives into our term sheet, is actually understanding the property in which you are leasing real estate. And one of the mistakes I see, and I'm going to slide the page down here, hopefully on the screen you can see it. One of the most common mistakes I see is tenants are so hyper-focused on the four walls of the space they want to lease that they forget that there is a piece of real estate, a building, that sits within the property in which they're leasing real estate in. And things that happen in that property affect their ability to operate. In the ideal scenario, they don't, and there are never improvements, and there are never mechanical, electrical, and plumbing issues in the building, and there are never issues with loading and that all goes smoothly. It rarely does. And that's really important. And I think, Jessica, to your point, there are also issues that happen in publicly owned space, infrastructure issues, issues of public sidewalks that oftentimes in the course of a long-term lease, tenants have to deal with. And in fact, there's very little the landlord can do in some of those situations. But part of it has to do with understanding the real estate in which you're located. And that is of absolute critical importance. And when you start to look from the term sheet, one of the things, as I was saying, that is oftentimes missed is there's always a definition of the premises. And that's the second provision here. It's kind of, what is the exact space you are leasing? Ideally, you have a floor plan with that. You know exactly how many square feet it is, and you know what comes with that. But oftentimes, there's a failure to define the actual property. And I think there are a whole bunch of reasons why that is really, really important. So those are the first two issues. And again, you know, while these are issues that go into a term sheet, there are, of course, issues that go into a lease, but there are also issues that should be discussed on your first tour. And one of the things I didn't hit on in the introduction, which will come up in the term sheet, is also understanding and making sure you understand who it is you are dealing with on a tour. Is it a broker? Is it a landlord? Is it the landlord's cousin? And I think that is really, really important. I would say typically what we're seeing in this market is that, and there are fees, and John, this is how you end up getting paid, and this is how Graffito gets paid. There are fees associated, transactional fees associated with leasing space that are paid to brokers. Almost always in the commercial context, these fees are paid by landlords. It is not an always. And it doesn't necessarily mean that if you're a tenant with a broker and you walk into a space in Cambridge or Somerville or Boston, especially with a landlord that may not be a corporation or an investor, hang on, Jason's trying to join again, that landlord's going to be prepared to pay a fee. And I think that's one of the things you want to be really upfront with a broker and with a landlord is who's paying the fee to the broker. I've seen a lot of disputes that have happened because of this, and whether or not there is a broker and who the broker represents, right? And that is a threshold issue, just like defining the property. I think a good broker on the tenant side can help with this. A good lawyer can help with this. But it is really, really important. And I think it also goes back to understanding who it is you're talking to in the leasing process and making sure the information you're getting is comprehensive and reliable. So it's a lot kind of packaged into the idea of understanding the building in which you're leasing and the real estate in which the space you're leasing sits within. But again, it is really, really important. So in terms of definitions, the other things that are important are understanding who the tenant is and who the landlord is. And I would say the term sheet I'm sharing now, as we dive in, it is very rare that we see term sheets or letters of intent, as they may be called, as comprehensive as the document I put before you. Frankly, we use these in almost all the deals we do. And we issue them as a landlord's representative. In the rare circumstances, because we represent a few tenants, we will put this together on the tenant's behalf. So these are not issues that are either landlord issues or tenant issues. These are all leasing issues that I believe need to be fleshed out. And even if there is no formal process for a letter of intent or a term sheet, these are things that I believe need to be fleshed out and start to be discussed on your first tour and actually should be resolved before spending a lot of money on negotiating a lease document. The one caveat is for many small businesses, they may not feel comfortable or have the experience negotiating some of these what I would call business issues that we'll get into, and a lawyer could be really, really helpful doing that in the absence of a broker or just a trusted third-party advocate. But again, this term sheet probably won't exist. Most landlords won't issue it, but it is certainly something, and all of these provisions are things that need to be fleshed out before significant resources get spent on a lease and before a tenant dives into a lease. Does that make sense to you all? Because I think it's a critical point. All right, I got one yes. I'm going to assume silence means yes as well. So some of these things are going to feel, some of these provisions that I'm going to flag, such as who's the tenant and who's the landlord, they're issues that oftentimes are not negotiated. Jessica's comment's good. Talk through fully before fine print time. It's exactly right. And I think including that are the next two provisions, the tenant and the landlord. Who are they? These are critical. I think from a landlord perspective, landlords certainly want to understand who they're doing business with. The language I actually put in here says ID the legal entity or the legal entity to be formed. It is okay oftentimes for tenants not to have an LLC set up or another corporate entity set up when they're looking for space. And I oftentimes see the mistake that tenants sometimes, before going to lease, spend a whole bunch of resources creating a corporate entity, especially first-time operators, when part of that organization is going to have to do with some of the things, could do with some of the things in the lease document. So it is okay not to have that resolved, but a landlord's always going to ask for it. You should always know who the landlord entity is. And I think one of the other threshold issues here is being able to articulate in a clear and comprehensive way what the use is. And the tenant should drive this definition. And from a tenant perspective, this definition should be as broad as possible to allow the tenant to be as flexible as possible and to pivot over the course of a lease term. Critically important. The landlord will probably, and we typically do, push for a more narrow definition of what it is can happen in the space. And the use provision in the lease, excuse me, the use provision in the lease is incredibly important. Part of the reason is that the way almost every lease is written is that if the use is not within the quote permitted use, that would be an event of default. So from that perspective, that's why tenants want to have a lot of wiggle room. That's also why landlords want to actually tailor something, a provision in the lease that is narrow enough where they understand what the tenant can and can't do in their premise from a use perspective, helps them with leasing other spaces. And it also helps them when they have to go back to the tenant when the gift shop they rented space to decided that they wanted to turn into a taco joint, right? And these are things that we see happen. It also relates to assignment, and it also relates to subletting, which we'll get into later. So the proposed use provision in the lease, I can't say it enough times, is if not the one of the most provisions that you will have in a lease document. It requires a lot of deliberation, and it requires some careful drafting. It is both a business and a legal issue. So moving on, I'm going to go through a few more provisions and then kind of pause for some questions. Hours of operation is something that's oftentimes looked at as part of a permitted use provision. We like to separate it. Regardless of how it's dealt with, it's really important to think about. There are two ways in which hours of operation provisions impact tenants. The first is sometimes it'll be written in a way that defines the minimum hours. So it will say you must be open for business, 5 days a week, these hours, right? And a lot of landlords, many of our clients want to make sure that storefronts are active. The flip side is that tenants don't want to be open for business if whether it's on a Sunday or in an evening or an early morning, depending on their use, if it's not going to be, if they can't generate revenue, frankly. So the other side of the coin, if you're not talking about minimum hours, is maximum hours or permitted hours. And landlords may want to limit the hours of which tenants can operate. They may not want early mornings. They may not want late at night. But I think this is one of those things, that certainly needs to be thought through and is more than meets the eye oftentimes. There are a whole bunch of ways of baking in flexibility. Most of the leases that we negotiate, there may be a variation for minimum or maximum hours depending on the day of the week, and there's a seasonality element to this as well, or can be certainly. I think this is particularly true with food and beverage, and of course it's always going to be subject to city regulations and rules. So what's the property? What's the premises? What's the use? When can be open? Again, threshold issues. And I'm going to pause here once again to allow any of you to ask questions about kind of these first kind of concepts. And from here, we'll roll into discussing things like rent and additional rent, the kind of nuts and bolts of who pays for what. And I think then we'll end with some of the additional provisions having to do with licensing, permitting, build out, and certain other rights. So that's the way I'd break up this discussion into 3 parts. And we just finished our kind of first part about some of the threshold issues in the lease. So I'll give some time for questions, and then we can dive back in. Jason, Jessica, anything? All right. So we've kind of talked about these call them foundational issues. Now we're going to talk about some areas that require oftentimes significant negotiation. The first one is the term. How long of a lease is the tenant and the landlord committing to? What we're typically seeing in Cambridge is terms that vary from, in the retail context, terms that vary from 3 to 10 years. Oftentimes tenants, the more money they're putting into a premises, they need to get a return on their investment. They'll want a longer lease term. Another reason for tenants wanting a longer lease term is to lock in rent and give themselves right to the space for a longer amount of time. One way of dealing with the longer amount of time riddle is also, and this is very much a tenant-friendly provision, is negotiating a renewal right, extension options into the lease. So the way this might work would be you would have a 5-year initial term with 1 5-year extension option, or a 10-year initial term with 2 5-year extension options, or frankly, a 3-year term with 2 1-year, or a 3-year term with 1 3-year. It comes in all different shapes and sizes. I think from an office perspective, offices typically in office leasing, there's quite a bit less investment at times. So office leases may be a year or 2 years. They can also be 10 or 20. To give an example, the office lease I have for Graffito, which we actually have a coffee bar in our space, we signed a very odd lease that was a 1-year initial term with 2 3-year options. So I was able to negotiate the right for 7 years to a given space. But when I went into it, I had a little bit of leverage with the landlord, and I knew I wanted to open this coffee bar. I didn't quite know whether or not I could pull it off from an economic perspective, from a permitting perspective. So I said, look, here's my goal. Here's what I want to do. I'm willing to take some real risk here by signing a 1-year lease, which the landlord, I think, was great about it. And within the first 6 months, I'll let you know if I want to extend for 3 years. And largely it's going to be whether or not I can kind of work out this coffee bar situation. So I signed a 1-year lease, and within 4 months of that, I gave the landlord notice that I wanted to extend for 3 years, and that worked really well for both parties. The other thing when you start thinking about the extension period, if any, or the option term as it's often called, is what is the rent going to be in that option term? I think from a tenant perspective, it's probably best to pre-negotiate what the rent would be. From a landlord perspective, oftentimes in markets, especially in Cambridge, where real estate pricing is changing relatively rapidly, they meaning the landlords will push for a provision that essentially sets rent at what is fair market rent. Something that is somewhat subjective, candidly, and can be a negotiation in itself about what that is. So from my perspective, from a tenant perspective, I prefer to see fixed rent so you know what you're going to pay when you renew for your additional 3 years or 5 years or further. So that's term and extension term, and it kind of touches on, as we said, what is the rent? So many tenants look at leasing as one question: what is the rent? It's obviously far more than that, but the rent is really important. And the one thing that I think is most important before asking what the rent is to understand what basis is rent being calculated. And I see two ways of doing this with a couple different variations. And again, these are threshold issues. This is kind of first tour type question, or even first phone call before the tour type question. Is the rent, the base rent, triple net, or is it gross? And a lot of you will hear the term triple net. Triple net essentially means, and you should understand it to mean, that the tenant is paying a base rent number, and in addition to that, there are certain triple net charges that the landlord will pass on to the tenant in proportion to their usage of the property. Or if it's a single tenant building, they will pay all of the, for example, maintenance for the building, real estate taxes for the building, water and sewer for the building. So it is absolutely critical to think through, in addition to the base rent, what else am I paying for? These things also will include at times certain utilities. So the base net rent, the additional rent, and the utilities should all be understood together, because these are all potential elements that are going to create financial burden on the tenant. And the way in which the lease or the LOI, but typically the lease, fleshes out what the amount could be. Is there a basement? Is there a cap? Is of absolute critical importance. Is one of those things I think a lot of tenants who haven't done this before forget, that just because somebody says it's a $30 rent, well, what are you paying on top of that? And how is that being calculated? And that is probably the source of most, I wouldn't say most, that is certainly a source of many conflicts and kind of landlord-tenant disputes, is what is included in the additional rent. The gross scenario is whereby there is one amount of money that is being stated that is what you pay on a monthly or annualized basis. And that includes everything except often your own use and consumption of utilities, right? So stepping back, one of the questions is, how is rent calculated? Not just what's included in rent, but how are we talking about rent? What I'm seeing most typically in Cambridge is that rent is being quoted on a annualized per square foot basis. So when you hear this space is $30 per square foot, what that translates to is you are paying $30 per square foot every year for that space. So 1,000 square foot space, $30 a square foot, $30,000 a year, divided by 12, that gets you to your monthly, right? Relatively simple concept. The challenge becomes when folks are quoting monthly rent, when folks are quoting overall amount of rent, and there's a translation that really has to happen in order to compare different assets in different language to each other. So again, just to review, the most common with our clients, what we're typically seeing is base rent, and on top of base rent, certain charges that are passed through the tenant. The language I included here in additional rent is a fairly standardized way of articulating it, which says tenant shall pay its proportionate share, meaning 10,000 square foot building, I lease 2,000 square feet, I'm going to pay 20%, my proportionate share of real estate taxes, insurance, and common area maintenance commencing upon the rent commencement. Standard triple net language. Common area maintenance, that can be negotiated. So for example, if I'm leasing space in the base of a ground floor building, and that building has elevators, and I'm on the first floor, and my trash and loading is on the same floor outside, and I have no reason to go up and down in this building, I would argue I should never have to pay for any expense associated with an elevator. Simple concept. Leases oftentimes need to be scrubbed to make sure that concept is captured from a tenant perspective. So that's one example of the nuance to common area maintenance. Another example, landlord is going to charge back for certain maintenance like shoveling. Well, what about ice removal? All these things come into both the obligations as well as the expenses that are getting charged back that tenants really want to understand. There are many tenants, particularly that are open 7 days a week, that I've seen say, look, I don't want to pay, it's my liability. My business depends on snow shoveling and ice removal. I don't want to pay you to do it because it is so critical to my business that I do it right, that I'm going to take on the burden and the expense to do that in front of my storefront. And I'm not going to pay you a common area charge for your guy to show up, once during the course of a storm with a snowblower, right? So these are things these are things I think you can all imagine become real issues in leasing and kind of affect this concept of what is and what is not additional rent. One thing I would throw out from a tenant perspective that I really like to see in leases that landlords rarely agree to, but it's worth asking, is some sort of cap on additional rent. The challenge is that there can be runaway costs oftentimes, or charges. What if the building needs a new roof? Great question, right? What if the building needs building systems redone, whether it's HVAC or plumbing. So I think caps on what can be additional rent are really important. We do see those happening. It's important to ask. It's really important for the tenant to protect themselves in that way. So utilities similarly is who is paying for what, important issue. And the other element of that is, am I getting a space that has a separate meter, or is there a sub meter? And if it's a sub meter, so for example, there's that 10,000 square foot building of which I'm leasing 2,000 square feet has one electrical, has one electrical panel, or meter, I should say, and you've got 4 different tenants running off that meter. Are there check meters? Are there sub meters? How is that electricity usage being billed back to me? Again, really critical issues all need to be addressed, and I think need to be addressed pretty early. And no doubt these issues need to be discussed often. So the last issue to discuss in rent is kind of a nuance that we're seeing quite a bit, and that we're using in many of our projects, particularly for restaurants, and that's percentage rent. Percentage rent is a concept whereby in exchange for example, a landlord helping with a build out, putting in money to help a tenant build, giving a rent break at the beginning of the term, or just negotiating lower rent, they will essentially say, I also would like to make a certain percentage of your revenue over a certain point. So just to make it real, a given landlord makes an investment into a piece of real estate, negotiates a deal with a tenant, and says, look, fair market's $40. I'm going to do a deal with you at 30. I'm going to put some money in. I need some sort of metric that if you do really well, the way in which I think you're going to do, to at least see some upside or get a further return on my investment, and at the same time allows me to give you a little bit of downside protection. And what I would like, and what's typical in the restaurant business, is anywhere between kind of call it 6 and 8%. I would like 6 to 8% of all sales over a certain break point. So let's say that break point is $1 million. Every dollar over $1 million, I'm going to get 7% of. And that rolls into rent. And when you hear percentage rent, that's what it's referring to. The challenge with percentage rent is that you have to negotiate 2 things, really important things. What is the percentage being paid? And what is the break point at which you are paying percentage rent? I've seen far too many examples, and I think far too many would be just one, but I've seen far more than one, far too many examples of tenants who agree to percentage rent with no break point, which means I'm paying you, the landlord, $30, and on top of that, I am paying percentage rent. The better way to do it is to say, look, I'm going to pay you $30 until I get to a certain point, and then I'll pay you percentage rent on top of that. So that's the concept of percentage rent. So all these things, base rent, additional rent, utilities, and percentage rent, that's where tenants spend a lot of time negotiating. There's some nuance there. It's obviously of critical importance. These are the core economic considerations in a lease. The last one I'll touch on is, and then again, we can pause for some questions. The last one I'll touch on, which relates to economics and is of critical importance, is when does the rent actually start? A lot of tenants believe the moment in which they get keys to a space is when they have to start paying rent. That is not necessarily true. My argument, if I'm working on a tenant behalf, and as some background before Graffito and in parallel with kind of the early days of Graffito, I was doing, as an attorney, a bunch of lease negotiations for tenants. And one of the arguments we would always make was, look, if I'm coming in and opening a store or a restaurant, whether it is, fitness or a barber or a cafe, I've got to make all these improvements, oftentimes upgrades to the systems of the building or a storefront, new windows, doors, whatever it is, things that improve the value of your building. I'm not going to come in here and make all these improvements and pour all this money into your building and also pay you rent on top of that. And that's why in this, what I broke out the idea that there's a date in which the lease starts, which oftentimes, although not always, is when you get the keys. And I think it's really important we remember there's another date in which tenants can negotiate when does rent begin. And they can be 2 separate dates. And I think it's really important to keep that in mind. And I think for businesses starting off, whether it's their first, second, or third business, those early days are the days in which more money is going out the door than it's coming in the door. And, from a staffing, from a labor, from an inventory, from a soft cost perspective, it's really important to think about rent as not just how much it is, but when you start to pay it. And this is something that I think folks miss quite a bit as well, particularly in the retail context. So I'll stop there. And again, do the same thing I did at a couple other points here, is see if there are any questions before we kind of continue on and go into kind of the second page of this LOI. You have 10 more seconds.
Hi there. I have can you hear me?
Yep.
Okay, great. I do have a question, and I'm not sure if this is the right place in the presentation to pose it. So let me know if circling back to the concept later would be more
Do it now,
appropriate.
no matter what it is.
But one of the things that we are struggling with here in Union Square is this dynamic of landlords anticipating the green line coming, and we're a pretty hot real estate market right now with significant development on our horizon. So there's situations where some property owners are land banking and not really doing much with their spaces, and then there's others where those current property owners are really increasing rents in anticipation of this transformation that is really still on the horizon. We're just beginning. So Union Square Main Street is spending a lot of time thinking about this challenge, and here's why. We're a hot market where a lot of people want to be because of location, for sure, proximity to Kendall Square, Boston, and so on, but also because people like the vibe here. The locally owned businesses, immigrant-run businesses, creative enterprises that make up most of the tenant base that is in our district is what is the lure and the magnet to so much other activity that's happening. And so that's a real challenge that we're encountering. And in my role, I'm spending a lot of time thinking about how to facilitate conversations between property owners and either existing or potential tenants that fit into these categories that, quite frankly, just cannot meet what they're hoping to get into a lease with in terms of rental per square footage. So the conversation that you just took us through with the different negotiating points makes me think that this might be a good time to ask your thoughts about that sort of big picture question. And I go back to hoping to encourage property owners to understand it's those kinds of businesses that are going to drive interest in the upper floors of the buildings, for example, and greater return on their investment in the long term. And it's really just a challenge.
Yeah, and it's not a unique challenge to Union Square. We see it all over Cambridge. Pardis is nodding her head. So, and I would say, just in full disclosure, we were working with a master developer. And I think one of the reasons the master developer was probably chosen is they recognize your last point, which is that the way in which you drive value in the upper floors and in a neighborhood scale isn't necessarily by getting $5 more or less on the ground floor and squeezing a retail tenant, right? And what's creating value in Union Square or Inman Square or Harvard Square or Central Square or North Cambridge is kind of the character of the ground floor. And to be really honest, and this is something I've said many times, is the reality is that there are good landlords and there are bad landlords. And there are landlords that care about the communities in which they're located, and there are landlords that don't, right? And there's a lot of education that can happen for certain landlords to help them understand what is truly in their best interest from a long-term perspective. But that education really won't work if landlords just don't care. And I'm saying this bluntly, but some landlords just want to get the most they can possibly get on a per square foot basis, don't necessarily care who the tenant is, and may have a whole bunch of pressures because of the way in which they bought or financed the real estate. And those are really hard hurdles at times to get over. And I think the question for many neighborhood organizations is, where do you spend your time and energy, and who are the landlords you actually seek to educate and help? Because there are some that are going to be receptive, and there are some that just may not be. The issue of land banking is challenging. One thing that one thing that many landlords don't understand, and I think this is part of the education, is that in the retail world, unlike office, unlike lab, but in the retail world, most typically, rent is just a product of revenue. End of story, right? If you're a national chain, you can spread that out over multiple units. There are marketing reasons, there are positioning reasons, but for small local owner-operated businesses, rent is a product of revenue. It does not matter the green line is delivering in 2021. That doesn't make me any more money in 2018 or 2019, right? And that's part of the education that I think certain landlords don't quite understand, is that when they're speculating, retailers cannot speculate. If they do not make money, they will not be open, and they can't wait 3 or 4 years. So these are challenging issues. They're issues that we deal with quite a bit. We're very lucky in that the projects we select and the landlords we work with generally understand this. And there are very, very few exceptions. And they understand that oftentimes there is a trade-off and there's an allocation of risk that they may be more inclined or less inclined to take to improve the value of an asset, to do something they feel good about, to give them a chance of getting some percentage rent. All sorts of things go into this. I think it's a topic that I can touch on at the end in the landlord perspective, but it is a really, really hard one. And unfortunately, some of these things are not able to be negotiated. You either have a landlord who gets it or who doesn't. And that's a really, really hard thing. I think in many ways, having tenants who are able to articulate a business plan and a structure whereby the landlord, percentage rent's a great example, can lower the barriers of entry, give them an opportunity, and if they do really well, maybe they can pay some more rent, right? Not all their rent, not all their profit, but maybe there is some revenue sharing there. I think there are other ways in which tenants can negotiate around term. Can say, look, if you think your real estate's going to be that valuable in 3 or 4 years, that's great. You're in a great position. I'm happy to put a little bit of money into your space in the short term, and I'll sign a lease for 5 years. Term is a way you can play with that. I think the pushback is that you're not going to put a ton of money into a deal that you have limited duration, that you have limited term. So one thing that I've seen work from the tenant perspective is say to somebody, look, you think this neighborhood's going to be so valuable in 3 years? That's fine. Give me a 3-year lease. I'll pay you X amount in rent. And in fact, of that X amount in rent, which you may continue to sit on this for years, I would ask you to put this amount into this space. So therefore, the landlord's putting in some money, the tenant's not, and the landlord's kind of putting in less money than they're getting in rent. And there's a way of playing through risk and also kind of playing with the landlord's expectation of future value that way. But again, these are hard issues. So, I don't know, Jason, if you would add anything. This is certainly something we deal with in East Cambridge, no doubt. It's almost harder. My feeling is actually that, we've done so much leasing in Kendall Square that has been primarily about how do you improve value of the overall neighborhood, and it hasn't been about squeezing tenants or waiting for real estate values in the ground floor to go up. That I think it's actually easier for us to work with landlords in Kendall Square than it is for us to work with certain landlords in other parts of East Cambridge. And I think part of that is also because of the kind of landlord it is. And Jason has nothing to add. He's having a hard time with connection. Sorry about that. I think that the perspective, you own one piece of retail real estate that's 4,000 square feet and you've got a mortgage, well, that's different than if you own a building with 4,000 square feet of real estate and 50,000 square feet above. So I wish you luck on this one. I'm happy to talk to you more about it, but it is a challenge. So I don't know. Hopefully that raised some more questions and answered a tiny fraction of your question, Jessica.
Thanks for fielding it. I knew it's a tough one, but I think the conversations are important to be having as much as possible.
Totally. Yeah, and I think that's right. And I think the question is, how do you empower and educate these landlords? I think it's a big one.
Great. And just to mention, I need to step away for about 2 minutes, but I'll be back with you in just a bit.
Sounds good. So we're going to keep on going here. We get on the second page, security deposit is still in the first, but I'm going to kind of move forward. Security deposit is a really important issue for tenants. I'm of the belief, although I've recommended to many tenants to go against this belief, that a retail tenant should never sign a personal guarantee. Oftentimes that's not realistic with somebody who has no track record, especially when a landlord's putting in money to a space. I will still say to tenants, do not sign personal guarantees. The way in which you get around that is through a security deposit. And the conversation around security deposit and guarantees is all about protecting landlords in the event of default, in the worst case scenario. And there are all a bunch of different ways for tenants to put, call it skin into the game. That's a term that landlords talk about a lot. It can be reputation. It can be the reality that that $50,000 or that $10,000 they're spending on the build out is a relatively tremendous amount of money to that tenant. And that's as significant as a security deposit or a guarantee. But I think these are two economic issues that are highly negotiated. The landlord wants as much as they get, the tenant wants as little as they can get, and it's typically through a combination of a guarantee and or a security deposit that it is remedied. It certainly relates to and can only be understood in the context of who's putting what investment into the space. And this gets us to our next section, is thinking about what work is a landlord doing in a space and what work is a tenant doing in the space. And these are also really, really important provisions for a lease document. The most common examples of landlord work, the landlord agrees to do this before the lease commencement, are HVAC improvements, storefront improvements, bathrooms, electrical upgrades, etc. Oftentimes the tenant is going to be responsible for almost everything else. Not always, but often. And I think fleshing out what is the landlord going to do, what's the tenant going to do, has to be done, again, early, has to be discussed in a comprehensive way. And in some of the deals that we're working on, and this relates to, all has to do with kind of risk allocation, frankly, and has to do with the kind of landlord you're dealing with. We're seeing landlords, instead of, for example, doing those HVAC or storefront electrical upgrades, saying to tenants instead, look, we'll give you a budget of X amount of dollars per square foot to do all your improvements. So I'm going out and leasing that 2,000 square foot space. A landlord saying, look, I will give you a $50 a square foot allowance to improve the space. That's $100,000. Really significant money. That's a big number. We've seen far, far, far bigger numbers. We've seen many deals that don't have those numbers. But that is something that is becoming more the norm, certainly in Cambridge, and I think will become increasingly more the norm as kind of it gets more competitive, getting better tenants. But this concept of landlord contribution is certainly a real one. I think it also triggers the prior conversation we just had about security deposit and guarantee. The more money the landlord's kind of fronting, the more of a security deposit or guarantee they're going to want to have. And similarly, I think that the more money the landlord is fronting, that could be looked at as, is it just free rent? So in lieu of putting in or giving a tenant a check, maybe I say, look, you get 6 months from the time in which you open. But again, these are all things that within a given context and a given landlord and tenant relationship in a market will really depend on the desirability of the tenant, the desirability of the real estate, and the economic resources, candidly, of both the landlord and the tenant. So moving through, and I think we can go pretty quickly through the end of this term sheet, and I hope you're all realizing that by going through this quote term sheet is really going through the threshold lease provisions, and that was the intent, obviously. Lease assignment is something that tenants need to be aware of. They will never have the right, rarely I should say, have the right to just assign a lease or sublease a space without landlord's consent. If they have the intention of doing this, or if it's part of their business plan, it is certainly something that has to be addressed very early. Similarly, oftentimes leases deal with a share of stock or membership interest as an assignment, and that's something that tenants really need to look out for. Permits, licenses, and approvals. Again, typically this is on the tenant. I included some sample language, which reads as follows, and this is pretty typical language. Tenant shall be responsible for obtaining all necessary regulatory permits, licenses, and approvals for conducting its business at the premises, with the exception of. So are there things a landlord's going to do? Furthermore, I think this is one of those provisions that, as we talked about at the beginning of the session, really important to flesh out with the city. what are those licenses I will need for my given business in this space, in this location. And I think that it's a zoning issue, it's a permitting issue, it's an approvals issue. With food and beverage, it can be health department issue, it can be a liquor license issue, but most oftentimes, this lies on the tenant. And that's, again, something to really keep in mind. Contingencies I put in here. We're seeing less and less contingencies, but oftentimes contingencies will be things like related to permitting. If I cannot get a permit for this use, I have the right as a tenant or the landlord to walk away from the deal. When I first started in the business, the kind of early 2000s, when I was doing quite a bit more leasing, it was much more common to see financing contingencies, whereby a tenant would say, look, I'm going to commit to this lease and this deal, but I need 60 days to ensure that I get the financing from a bank or investors before the lease fully goes into effect. We're seeing less of this, but contingencies is certainly something that need to be discussed and is really a core business issue. I would argue many of these issues here are negotiated in a lease, but actually are business issues. And hopefully that's coming across loud and clear. And I think these are many issues that, if you feel comfortable, I should say if the tenant feels comfortable, they can negotiate many of these. Not to say a lawyer's not needed or broker's not needed, but by no means, in most of the deals that I'm working on, these things get negotiated between business owners and principals of companies before they go to the actual attorneys, which A, is a cost-saving mechanism, and B, makes sure the threshold business issues are being negotiated by the actual business people. Something, again, that's obviously really important. I put in the list signage rights and parking rights from a retail perspective of critical importance. Signage rights, the way I drafted, or kind of the way I wrote in my notes, they should be negotiated up front. They'll always be subject to city regulations, but they're ideally at the tenant discretion with some sort of envelope or some sort of general definition of tenant rights by the landlord that is as objective as possible, frankly. Parking rights is something that's important. Again, should be fleshed out early. Similarly, trash and loading. For restaurants in particular, I think this is a landlord-tenant issue that needs to be worked out very often. I know that if Jessica's back on, she can probably echo the reality that in a district like Union Square, certainly Jason in East Cambridge, where you have a lot of compression of the built form, trashing and loading, it can be challenging. Is it happening out front? Is it happening behind? Are there shared zones where this is occurring? Is the city going to prohibit certain procedures and approaches? How is the landlord providing within their property the ability to mitigate some of the city challenges? So again, these are business issues and really should be fleshed out. The last two are quickies. Brokers should be identified in a term sheet and a lease, so there's no confusion about who's paying and whether or not the landlord and the tenant are represented, of critical importance. And the last thing I'll say is, we went through this whole term sheet. I mentioned at the beginning, most landlords and tenants do not take the time to memorialize in writing these critical issues. Even when they do, they're always non-binding. I've seen almost zero situations where a term sheet or a letter of intent is binding. There may be certain provisions that get worked in, like confidentiality, which end up being binding. But oftentimes these term sheets are really used to guide the attorneys, the other consultants, on what has already been agreed to between a landlord and tenant. And whether or not it is done on letterhead like this or done with this many provisions, this stuff must be negotiated. It will all go into the lease. And I think if tenants can bang through all of this stuff, the leasing should not be difficult. These are the critical business issues, which the nuance of such become legal issues in a lease. But again, the business folks should decide those business issues before going to lease. And I think that's the major takeaway for this session today. I'm really hopeful this is given in a relatively short amount of time a good overview. I want to save some time for questions, and we only have 15 minutes or so left, but I'll close just kind of going back to my agenda just by referencing a few key things. Tenant team. Really important for tenants to think about who's on their team. Who do they need to execute on a project? Do they have a broker? Many do not. Do they have an attorney? Almost all should. Who's their architect? Who's their contractor? Who's helping them do the due diligence on the physical space, and then perform the actual design and construction work a space needs? Do they have a good banking relationship? That's another big one that I think is really important. And, the issue of business versus legal issue, I think I hit on that. I don't need to kind of go further there. But what I did include in the package, and as you'll see in these pages as I flip through, just for all your references, an example of a short form lease, which has a few tenant-centric comments in it that I think are kind of fairly typical of what a lawyer might put in, and those are shown in red. And a few kind of important elements having to do with landlord representation. So, for example, the provision that is here, landlord representation obligation, landlord represents and warrants to tenant that. This is one of the most important things you're going to see in a lease document, whether it's a short form or long form. What is a landlord representing? What is their responsibility? What are their obligations, right? And again, this is in all leases. It really is something a tenant should understood at the very early stages of a negotiation around a space. So that takes you through the deck to the last 2 pages, which, in lieu of burdening you all with a 40-plus page document exhibits of kind of what a standard lease would be, I just included a table of contents for what a long-form lease is. So that's there. And, at this point, it really concludes what I wanted to cover with all of you. So I will open it back up to any questions. No pressure at all. If there aren't any questions, we can kind of close out here. And, my contact information is at the header here. And obviously happy to field any questions after this. So I'll turn it over to you. And actually, before I do that, Pardis, I'm seeing sitting across from me has some questions as well.
Oh,
or a comment.
Yeah, I just wanted to comment. Hopefully, folks can hear me. Especially for Jason and some of the Cambridge folks. We have one-on-one coaching with an attorney that will start back up again, hopefully in July. So if someone you know is maybe renegotiating a lease or would just like someone to review their lease, we have an opportunity to give up to 2 hours of free legal service to small business owners. So that's something especially important in the area of East Cambridge. Jason, if you know folks, feel free to send them our way.
Yeah, I also had a plug for CDD, which is I think there are a tremendous amount of resources that tenants just aren't aware of. And I think even sending them over to the City Hall Annex, I was walking in, I was reminded, am I getting this right? Yeah, of the storefront improvement program. So there's a lot of stuff, and I applaud kind of Pardis and her team, and obviously Jason and folks like him who kind of have done a good job liaising there. So Jason, I interrupted.
Sorry, I don't know how well my connection's working on your end.
Yep.
I guess my question was, how, for some of the small landlords, how well do you think that they understand maybe the obstacles that small business owners that want to rent to them face when they go to rent their spaces? So for instance, we have a new business that's moving in on Cambridge Street, and I was talking to them about their sort of leasing process. They were able to negotiate 3 free months of rent that they had anticipated using for build out time, which is great. But in reality, what it translated to was waiting for a BZA hearing, waiting for the appeal period to finish, and then starting to go get their permit. So they've eaten up basically their 3 months. I'm just curious, do you think that landlords understand that when they're trying to do they go in with that type of expectation when they're renting to a new business?
Great question. Some landlords know it and they just don't care. Some landlords feel like, look, I can only take so much risk. I think a lot of this depends on the tenant advocating for themselves and educating the landlord, frankly, because a lot of landlords can be very apathetic, and they also know the ambiguity that surrounds some of this permitting. A big one actually has to do with just how long the length of term is. If I'm going to sign a 5 or 10 year lease, instead of saying I need 3 months or 6 months of free rent, I'm going to say my rent will not commence until the later of or the earlier of, that's in negotiation. But one of those provisions is open for business, right? The ultimate is rent will not commence until tenant opens for business at the premises, but in no event later than, and the outside date is much longer than you would expect you need. Some landlords get that and will agree to it, but oftentimes landlords want a cap. So that's typically how I've dealt with this: is let's make it actually open for business with a kind of a ceiling or kind of a capped date. And I think that's part of the negotiation with these landlords. The longer the space is sat vacant, the more leverage I think at times the tenant has. But at the same time, the landlords they're that much more eager to get rent in. So it's a great question. A lot of these landlords, they unfortunately they may even know it. They know how murky it is, and they may not be fully transparent with tenants. And a lot of tenants aren't doing their upfront due diligence. And to your point, 3 months is nothing. And if it's change of use, 3 months that barely gets you to a hearing at times.
Right.
Yeah, just to go with that, Jason, often, just because I've been doing some research on this lately, it is mostly the tenant advocating for themselves when I've asked business owners how they've negotiated this whole BZA term, if they have to get a variance or a special permit. And most all of them said, unfortunately, the only loss they had was if they didn't get the variance or special permit, they had to walk away. But that
which would be an example of a contingency that we discussed.
Exactly, yeah. And I've seen that quite often, more often or not, in almost all of the small business situations in Cambridge. But most people have been advocating for that free rent, if you will, for longer than 3 months if they can. But it's offline. You should tell me more about this situation.
Sure.
Yeah, I think one way of dealing with it is contingencies can work, but I think the real metric oftentimes is just rent commencement. And if it's a floating date, that takes a great place. Meaning, if it's based on open for business which is floating, as opposed to a fixed date, 3 months, 6 months, whatever it is, hugely advantageous to the tenant, obviously, and that's the ideal scenario. Jason, any other questions? Well, you got me. Although you can just bother me at any community meeting I see you at next, which is probably not too far from now.
I'm good for right now. Thanks.
Jessica, anything you want to touch on before we close out?
I think that was very, very helpful. Would it be okay to be sharing these term documents with businesses in Union Square? It's I think, a very helpful collection that walks people through sort of very important stuff in a concise way. And I'd just love to know that it would be all right to share it with the businesses in our district, if that is.
100%.
Wonderful. Thank you. And thanks for that. And thanks for this morning's conversation. I'll hope for a chance to meet you in person.
Yeah, likewise. I'm sure we'll meet soon. And thank you all. And I think with that, parties, unless anything else to add, we'll get to end this live webcast.
Yeah, so guys, thanks everyone, and this will be recorded, and I will send everyone a link so that if you want to check back on it, you were able to. Thanks again.